nti Phoebe yayanjulira omuwabirwa n'amuwanjulira Annette n'amugamba nti bali boogedde ejjo era oli n'amwaniriza n'amubuuza ebikwata ku mwana gwe yali aleeta era n'amala n'amubuulira biki byali byetaagisa n'amugamba nti yali alina okusasula emitwalo 19 nga giriko egy'okumuwandiisa omwana kuliko ejja daycare n'eza uniform.
The accused person who said he had no cash on him asked whether he could pay using mobile money, and he did so on the telephone number of Miss Annette.
Nti yagamba yali tatambudde na ssente nkalu n'asaba nti ssente aziteeke ku mobile money era n'aziteeka ku mobile money ya Annette.
PW7, that is Annette, asked PW6 to issue the accused person with a receipt, and the same was issued to him, and it was receipt number 2958 in the name of Zuriel Onyum.
Nti Annette kwe kusaba Phoebe ng'amuwandiikira risiiti era n'awandiika risiiti nga yali mu mannya ga Zuriel Onyum.
The accused then left the office promising to return with the child and the mother on Tuesday the following week. And I take notice that this was the week of Easter and the next working day was Tuesday of the following week.
Nti era yavaawo n'abasuubiza nti agenda kujja n'omwana ne maama w'omwana wiiki eddako olwokubiri era Oweekitiibwa Omulamuzi alabye nti yali wiiki ya Easter n'olwekyo olunaku olulala lw'okukola lwali lwakubiri.
The accused person then walked out heading towards the gate as Miss Namteri, who was still in the office of Miss Annette, bent down to keep the receipt booklet in the drawer.
Era yatambula ng'adda ku geeti Namteri yali asigadde mu ofiisi ng'ate ateeka risiiti mu drawer.
At that time, some children were in the compound playing, and as Miss Namteri rose up to look towards the gate so as to go and open for the accused person to exit the center, she saw the accused person bending while holding a child, and she thought that he was beating the child. She ran outside to establish why he was beating the child, only to reach there and find that the accused person, who was holding a knife, had already cut the neck of one child, and this child was Keisha.
Nti bwe yabadde afuluma abaana abamu baali wabweru nga bazannya nti era Phoebe bwe yagenda okusituka ng'agamba agenda agulewo geeti omuwabirwa afulume n'atunuulira mu dirisa n'alaba ng'omuwabirwa akuttamye ng'akuta omwana n'asooka n'alowooza nti oli yali akuba omwana n'adduka kumubuuza lwaki yali akuba omwana n'asanga nga yali alina akambe ng'amaze okusala Keisha.
And she was lying in a pool of blood. And the accused person at that time was reaching out for another child.
Yali mu kitaba ky'omusaayi ate omuwabirwa yali agenda ku mwana omulala.
Miss Phoebe asked the accused person why he was cutting the children, and she also threw one of the children's bicycles, which were in the compound, at him to scare him off. The accused person left the child and ran after her, threatening to cut her as well.
Phoebe bwe yamubuuza lwaki yali asala abaana n'amukanyigira n'akagaali abaana ke bali bazanyisa n'asooka n'akaleka n'amugoba n'adduka.
Miss Phoebe ran away from the accused person while making an alarm, but she fell down, and the accused person ran back to the children very fast. And by the time Miss Phoebe returned to prevent or stop him from cutting the children, she found when he had cut the second child, and she again threw a bicycle at him as he was pursuing the third child.
Nti bwe yamugoba oli n'adduka yadduka ng'akuba emiranga oluvannyuma n'agwa. Bwe yamala okugwa ono n'addayo mangu n'adda ku baana n'akwata omwana ow'okubiri n'amusala.
The accused person again ran after Miss Phoebe, and when she fell down, he drew the knife, threatening to cut her as well.
Nti era n'amukanyigira akabugaala akalala bwe yakamuganyugira oli n'addamu n'amugoba n'adduka era yagenda okulaba ng'akutte omwana omulala.
The accused person then left Miss Phoebe and went back to the children, and when she rose up, she found him cutting the last child, and the last child to be cut was Odeke Ryan.
nti era yamala n'amuleka oli bwe yagwa n'agenda okusutuka n'asanga ng'asaze omwana owasembayo ate yali asembayo baali bamuyita Odeke Ryan.
At that time, Mr. Net, who also witnessed the cutting of some of the children together with other caretakers, were making alarms which attracted one Cyrus Bukenya, who arrested the accused person. He was joined by Moses, the security guard, Bashir, and Timothy. When he was being arrested, the accused person threw the knife over the chain link fence. The accused was immediately locked up in the guardhouse at the gate to keep him away from the angry crowd which had formed at that time. And upon his arrest, the accused person was found with 2 new knives in his socks, and they were recovered from him.
Nti Aneti naye yali alabye nga asala abaana abamu ne keyateeka omulala eyaliwo bakuba enduulu, era bwe bakuba enduulu Cyrus Bukenya, Moses eyali omukuumi, Bashir ne Timothy bajja. Bwe bamala okujja oli n'abalaba n'asuula akambe n'akasuula wabweru wa geeti, era ne bamukwata ne bamugayira mu kayumba ak'omukuumi nga bamutaasa abantu abaali batandise okujja. Era bwe bamukwata ne basanga nga yali alina obwambe bubiri bupya mu stockings ze.
3 of the attacked children, namely Eteku Gideon, Kisha Agenroth Otim, and Ignitia Seryange, were rushed to Wensi Medical Center, which is about 300 meters away from the center, hoping to save their lives. However, they were pronounced dead on arrival.
Abaana abasatu Eteku, Keisha ne Seryange babatwala ku ddwaliro lya Wensi Medical Center nga balowooza bayinza okubataasa, naye bwe baatuuka ne bagamba nti bali bafudde.
Ryan Odeke, who was clearly dead, was left at the veranda but was also later taken to Wensi Medical Center by police.
Ryan Odeke eyali asigadde naye nga yali afudde, baali bamulese ku kabalaza naye oluvannyuma naye bamutwala ku ddwaliro lya Wensi.
The dead bodies of the 4 children were then taken to Mulago, Kampala, capital city mortuary by police, and post-mortem examinations were done on them by Dr. Atongole Abdul, who described the injuries on all the bodies of the 4 children to have been on the necks, and concluded that the cause of death for the 4 children was hypovolemic shock due to deep cut wounds, deep cut injuries to the neck.
Nti emirambo gino oluvannyuma bagitwala e Mulago mu ggwanika, era omusawo gwe bayita Akatongole n'akebera emirambo n'annyonnyola nti bonna baali balina obuvunne mu bulago, te n'agamba nti ekyabaviirako okufa babafumita nnyo ne bavaamu omusaayi mungi.
The police officers from Kabalagala Division of Police visited the center, which they termed as the primary scene of crime, and recovered the killer knife and the 2 other knives and a backpack which was also recovered on the accused person, picked some suspected blood from the compound, among others.
Nti abasirikale ba poliisi e Kabalagala bagenda mu kifo ekyo we battira abaana ne baggyayo obwambe bwe basangawo, ne baggyayo n'ensawo omuwabirwa gye yali alina, era ne batwalako n'omusaayi gwali mu luggya.
The samples recovered were subjected to DNA analysis and the report was admitted in evidence.
Nti omusaayi ogwo bagutwala ne bagukebera, era ebyava mu kukebera babireeta ng'obujulizi.
The police officers also removed the accused person from the guardhouse at the center amidst the angry crowd which desired to lynch him, and they took him to Kabalagala police station.
Omuwawabirwa bamugya mu kayumba k'omukuumi, era ne bamukuuma abantu abaali batuusawo nga bagala kumutta ne bamutwala ku poliisi e Kabalagala.
On 3rd April 2026, the accused person led the investigating team to his house, which he had rented in Chanja at Namgera Close, Katumba Zone. A search was conducted in the accused's house, and a number of items were recovered, which included electronic devices, 2 laptops, 2 mobile phones, and 3 hard drives, which were subjected to forensic analysis, and a digital analysis report was also admitted as evidence.
Nga 3 Ogwokuna 2026 omuwawabirwa yakulemberamu abali banoonyereza omusango guno n'abatwala mu nnyumba ye gye yali apangisa ekyanja era bwe bayingira ennyumba ne bajjaaza bajjamu ebintu nga laptop 2, amasimu n'ebintu ebirala.
The other items recovered were 2 American passports, a driver's license from the state of Virginia, a sanity report dated 30th December 2025, and 5 new knives, among others.
Nti ebintu ebirala bye bajjamu passports 2 eza America, bajjamu driving permit, ne bajjamu obwambe 5, ne bajjamu ne report gye bali bamuwandiikidde okuva mu ddwaliro nga bagamba omutwe gwe gwali gukola bulungi.
The accused was examined on police form 24 by Dr. Emmanuel Nwamanya, who testified as PW11, and he was found to be mentally normal. It was upon that background that the accused was indicted for murder in 4 counts, hence this case.
Nti omuwawaabirwa bamutwala ne bamukebera, ate yamukebera yali musawo gwe bayita Emmanuel Nwamanya, era yajjanga omujulizi w'oludda olwabi ow'okumi oluvannyuma ne bamuteekako emisango 4 gya butemu.
The accused person gave an unsworn statement and called 2 witnesses in his defense. He had mentioned 4 witnesses but provided only the telephone numbers but without any physical address. Only 2 witnesses were reached using the telephone numbers provided by the accused person, and efforts to trace the 2 were futile because the phone numbers were not on.
Nti omuwawaabirwa yayogera nga talayidde era n'aleeta abajulizi 2, yali asabye okuleeta abajulizi 4 naye nga tataddeeko wa gye bali babeera, n'ateekako amasimu gaabwe gokka. Okukuba amasimu 2 be basobola okujja, 2 amasimu gaabwe gali tegaliiko.
It is important to note here that one of the 2 numbers that he had provided that could not be reached was an American number.
Naye tulina okumanya nti mu masimu ago 2 emu yali ya America.
In his defense, the accused person did not deny killing the 4 children, but stated that he did not act intentionally or deliberately.
Mu kwewozaako teyagaana nti omusango teyagukola, wabula yagamba nti teyagukola mu bugenderere.
He stated that although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected and could have contributed to the death of the children.
Agamba nti wadde bagamba nti omutwe gwe gwali gukola bulungi, naye wayinza okubaawo ebintu ebirala bye bataalaba okulaga nti biyinza okuba nga byamuviirako okutta abaana abo.
He said he was not mentally okay, and he also denied being foul-minded in the killing of the children.
Agamba nti omutwe gwe gwali tegukola bulungi era agamba nti si yeeyagalira okutta abaana bano.
In respect to this, he referred to the book about war, which was part of the evidence of PW18, the digital analyst, who analyzed his flash disk and found that he had saved a book entitled The Art of War by Sanju. The accused person stated that he saved that file long before, and it cannot be said to apply to the killing of the children.
Nti waliwo ekitabo omujulizi ow'okumi olw'oludda olwabi lwe yayogera. Omujulizi ow'okumi yayogera ku kitabo ky'olutalo era n'agamba nti ono yali yakiteeka ku flash ye, n'agamba nti ekyo kitabo yali yakiteekako edda nga kisobola kubeera nga kyekyaviirako okutta abaana bano.
He also denied being deliberate and with forethought while making reference to the prosecution evidence of PW18, which revealed that using his phone, the accused person had made Google searches on subjects including ISIS beheading and for schools that teach young children. He said that although these searches suggest that he did it deliberately, there were factors that forced him to conduct them.
Nti ye yagaana ekyokugamba nti abaana bano yabatta nga kigenderedde, n'agamba nti omujulizi ow'okumi yagamba nti yakozesa essimu ye okukebera ebikwata ku ekitongole ekitima emitwe gy'abantu ekibayita ISIS ng'anoonyereza ku masomero g'abaana abato n'agamba nti
he said that although these searches suggest that he did it deliberately, there were other factors that forced him to conduct those searches.
Nti wadde bagamba nti bino byanoonyerezaako ebyamuleetera okutta abaana abo, waliwo ebintu ebirala ebyamuleetera okutta abaana.
During his testimony, the accused person further stated that he was under the control of some people whom he occasionally called friends, and that they fell into three categories. He stated that between January and March 2026, he entered an especially distressing period because he was contending with some people who were surveilling him, making many demands of him, and threatening to kill him. They began demanding money, and he noticed that they had all the capabilities. As a result, he left the Bunga neighborhood where he was staying and began sleeping on the streets.
Nti omuwawaabirwa yagamba nti bino byonna yabikola olw'ensonga nti waliwo abantu be yali ng'alaba engeri ssatu be yannyonnyolako n'agamba nti wakati wa January n'omwezi ogwokusatu yali mu kiseera ky'okwennyamira era ng'agamba abantu abo bamusabanga ebintu bingi ne bamusaba ssente ne bamugamba nti bagenda kumutta era n'ava mu kitundu kye yali abeeramu n'agenda n'atandika okubeera ku luguudo.
He stated that because of this, he tried to end it some way and somehow. And according to him, he tried several things to bring the whole thing to an end, including fleeing the country, robbing a bank, and killing his brother's family. He then concluded by saying that those said people whose names he chose not to disclose to the court influenced his actions of the 2nd of April 2026. He concluded his testimony by inviting the court not to honor the charges for murder against him because there were some circumstances that forced him to act the way he did on 2nd April 2026, and this is the date of the unfortunate incident.
Nti yatuuka ekiseera ng'ayagala kubikomekereza n'agezaako okwagala kuva mu ggwanga n'agezaako okubba bbanka era n'agezaako n'okutta famire ya muganda we n'agamba nti abantu abo batayogera mu kooti be bamuviirako okutta abaana abo olwati bye byamuviirako ebyo byatuukawo nga 2 Ogwokuna 2026.
Okay, there is a burden and standard of proof. This is known. The prosecution bears the burden to prove all the ingredients of the offense, or in 4 counts, beyond reasonable doubt. And I will skip that and I go to the ingredients of the offense of murder.
Oludo lwabi lulina obuvunaanyizibwa okuleeta obujulizi obumala.
Section 171 of the Penal Code Act, Chapter 128, which defines the offense of murder, provides that any person who, with malice aforethought, causes the death of another person by an unlawful act or omission commits murder.
Nti amateeka gagamba nti omuntu yenna ng'alina ekigendererwa n'atta omuntu mu bumenyi bw'amateeka aba attemudde omuntu.
For the accused person to be convicted of murder, the prosecution must prove each of the following essential ingredients beyond reasonable doubt. 1, death of a human being, that the death was caused by some unlawful act, that the unlawful act was actuated by malice aforethought, and that it is the accused person who caused the unlawful act of death.
Nti oludda olwabi lulina okuleeta obujulizi okukakasa nti mu butuufu waliwo okufa, nti okufa okwo kwali kumenya amateeka, nti ate omukufa okwo nti yakukola yali alina ekigendererwa, era abalina okuleeta obujulizi nga bulaga nti omuntu ali mu kooti ye yazo emisango gino.
I will discuss all the 4 counts together because they are supported by the same evidence. However, the third ingredient of the unlawful act being actuated by malice aforethought shall be addressed last.
Nti emisango gyonna ajja kugyogerako mulundi gumu okuggyako ekigendererwa kyagenda okwogerako kyokka nga kyawukanye n'ebiri.
And I will do it last.
Kyagenda okusembyayo.
Death of a human being or human beings. Death may be proved by production of a postmortem report or evidence of witnesses who said that they knew the deceased and attended the burial, also the dead body. And in the instant case, the fact that the infants, Eteku, Gideon, Keisha, Agenoroth, or Tim, Ignatia, Seriang, and Odeke Ryan are dead is not in dispute. And in proof of this, the prosecution adduced the evidence of Dr. Katongole Abdul, who performed the postmortem examinations on the bodies of the 4 children, and he confirmed that they were dead. The parents of these children, namely Apollo Stella is the mother of Eteku Gideon, Komakech Marvin is the father of Kisha, and Bazia Lawrence is the father of Seriange, and Okurutu Simon is the father of Ryan Odeke. They all confirmed that their children died and they were buried.
Ndikukulaga okufa basobola okulabira ku baluwa omusawo gy'awandiika nga amaze okukebera emirambo obujulizi bw'abantu abaali bamanyi abantu bano ate ne babaziika bagamba nti Eteku, Keisha, Seryange ne Odeke okufa kwabwe bonna tebakuwakanya kubanga omusawo gwe bayita Katongole yakola ripooti nga akakasa nti abaana bano baafa ate n'abazadde b'abaana bonna bajja ne bawa obujulizi ne bakakasa nti abaana bano baafa.
Also, the evidence of one of the caretakers, Miss Namtevi Phoebe, and the coordinator of the center, Miss Aneta Goye, who were the eyewitnesses to the attack on the children that resulted in their death, also confirmed that they are dead. And the prosecution also adduced the evidence of the divisional CID officer, Kabalagala, called Esserite James. He testified as PW15, and the scenes of crimes officer, he testified as PW14. They testified that they saw the bodies of the 4 children.
Nti Phoebe ne Annette be baaliwo nga balaba omuwawabirwa ng'asala abaana abo ne kibaviirako okufa era bajja mu kooti ne bakakasa nti abaana bali bafudde era ne baleeta abajulizi ow'15 n'ow'14. Ow'15 yakulira okunoonyereza emisango mu Kabalagala ne baleeta n'oyagenda gye bakoledde emisango era ne bakakasa nti bwe baatuuka mu kifo ekyo balaba abaana abo nga bafudde.
Having considered the evidence and in agreement with the joint opinion of the 3 assessors, I find that the prosecution has proved beyond reasonable doubt that the 4 infants, namely Eteku Gideon, Kisha Agenoroth Tim, Seriang Ignatius, and Odeke Ryan are dead.
Okusinziira ku bujulizi akaanyiza ne ba assessor bwe bagambye nga bagamba nti abaana bana Eteku, Keisha, Seriange ne Odeke baafa.
Also, the fact that the death was unlawful is also not disputed, given the account of the eyewitnesses to the offense and the nature of the injuries on the bodies of the 4 children.
Ekyokugamba nti oba baafa mu bumenyi bw'amateeka nakyo tebakiwakanya olw'ensonga nti waliwo obujulizi bwabo abaaliwo ne balaba ate n'ebiwundu abaana be babasanga nabyo.
And having considered the evidence and in agreement with the joint opinion of the 3 assessors, I find that the prosecution has also proved this ingredient beyond reasonable doubt that Eteku Gideon, Keisha Agenoroth, Otim, Seriang Ignatius, and Odeke Ryan, their death was caused by an unlawful act.
N'olwekyo Oweekitiibwa Omulamuzi akaanyiza ne ba assessor bwe baamuwabula nga bagamba nti Eteku, Keisha, Seriange ne Odeke nti omukufa kwabwe kwali kumenya amateeka n'olwekyo obujulizi bumala okulaga nti mu butuufu abaana bano baafa mu bumenyi bw'amateeka.
The participation of the accused person, in order to prove participation, there should be credible, direct, or circumstantial evidence placing the accused person at the scene of the crime as an active participant in the commission of the offense.
Ekyokulaga nti oba omuwawaabirwa ali mu kooti eyaza omusango balina okuleeta obujulizi obulaga nti omuntu ono ye yatta abantu bano obuliwo oba obujulizi obwetoolodde embeera ezaaliwo.
And in the instant case that the participation of the accused person is not contested because the accused person himself did not deny having killed these children.
Mu musango guno ekyokubanga yeyatta abaana omuwawaabirwa takiwakanisa.
I will proceed to also to look at the evidence that the prosecution produced to support the fact that it was the accused person who killed these 4 children. The offense occurred in broad daylight, specifically at 11 a.m. or thereabouts. The accounts of the eyewitnesses to the crime, namely Miss Phoebe Namtevi and Miss Annette Odong Agoye, the caretaker and coordinator respectively, revealed that the accused person with whom they had just been interacting in the office of Miss Annette was seen gruesomely and brutally cutting the 4 children with a sharp knife, which he threw out of the chain link fence upon seeing the first responders to the scene.
Nti kkooti egenda kutunuulira obujulizi oludda oluwaabi bwe bwaleeta era n'agamba nti ebintu bino byaliwo emisana zaali ssaawa 5 ez'okumakya nti ate waliwo abajulizi abaaliwo ne balaba nga Phoebe ne Annette ng'abo bona bakolera essomero eryo ate ne bagamba nti omuwawaabirwa baali boogera naye era nga yali yakafuluma era ne bamulaba nga asala abaana abo oluvannyuma n'asuula akambe wabweru w'eggeeti.
The prosecution further adduced the evidence of the scenes of crimes officer, Mr. Mutaka Jim, his PW14, and SRI James, the lead investigator, PW15, who testified to the effect that they responded and went to the center, which they referred to as the primary scene, and they found that the accused person had already been arrested by the first responders and was being kept in the guardhouse to keep him away from the angry mob that wanted to lynch him. PW15 SRI James then rearrested him and took him to Kabalagala police station.
Nti baleeta omujulizi ow'okuminabana ng'oyo yagenda mu bifo bye bakuzzaamu emisango bamuyita Mutaka Jim era ne baleeta n'omujulizi owa15 yeyo yakulira ebyokunoonyereza emisango ku poliisi y'e Kabalagala era nti badduka ne batuuka mu kifo ekyo bwe batuuka ne basanga omuwawaabirwa baali bamaze okumukwata nga bamuterese mu kayumba k'omukuumi nga bamutaasa ku bantu abaali baagala kumukuba era oluvannyuma omujulizi owa 15 n'addamu n'amukwata n'amutwala ku poliisi.
The prosecution also adduced forensic evidence that implicates the accused person by placing him at the scene of the crime, namely the evidence of AIP Odongo Emmanuel. He's a CCTV analyst, and he testified that police CCTV cameras on the roads and some private CCTV cameras showed that a motor vehicle RAV4 was seen being driven from Chanja, where the accused person was residing, through Nakawa until it reached Renewal Circle in Eggaba, where it was captured by the private camera of Renewal Circle on 1st April 2026.
Era baleeta obujulizi obulala obw'Abakakensa ne baleeta omuserikale gwe bayita AIP Odong Emmanuel ng'ono yeekebeja zi CCTV kamera oba kamera ez'okukubo era n'agamba nti mu kwekebeja yalaba emmotoka ekika kya RAV4 nga baagivuga kuva ekyanja bayita Nakawa ne batuuka ku Renewal Circle era ne kamera ya ku Renewal Circle n'emukwata nga 1/4/2026.
And this court takes judicial notice that the Renewal Circle, which is part of the Gaba Community Church Complex, is directly behind the center.
Ate kooti eraba nti Renewal Circle nayo eri kumpi ne kanisa ya Gaba Community Church ate eri kumpi n'essomero lino.
Upon parking the motor vehicle in the parking yard of Renewal Circle, the accused person was seen alighting from the vehicle and walking towards the center. This corroborates the evidence of PW6 Miss Phoebe, who testified that the accused person had come to the center on the 1st of April 2026, and had approached the gate of the center on foot. The accused person remained at the gate from where he had a conversation with PW6 regarding the requirements for enrolling his child at the center.
Ntera bagamba nti bwe yapaakinga ku Renewal Sacco yatambula n'agenda ku ssomero eryo, era kino kyongereza ku bujulizi bwa Phoebe eyagamba nti nga lumu Ogwokuna 2026 nti omuwawaabirwa yatambuliza ebigere n'atuuka ku geeti era ne boogera wamu ng'amubuuza biki ebyali byetaagisa okuleeta omwana.
The CCTV analysis report also revealed the accused person being ridden on a border on the day of the incident, 2nd April 2026, at 10:16:13. That is 10 o'clock, 16 minutes after 10 and 13 seconds. And he was carrying a black backpack.
Ntera report eyo eyazi kamera egamba nti omuwawaabirwa baamulaba ku lunaku olwo lwennyini ng'ali ku booda ng'azaali ssaawa 4:16 n'obusekenduzi 13 ng'ali yeetisse akasawo akaddugavu, akasawo ak'oku mugongo.
While in court, the witness, who was PW13, played the footage and the images, which clearly confirmed the movement of the motor vehicle on the 1st of April 2026 and the border carrying the accused person on 2nd April 2026.
Era bwe baleeta ezikamera ezo ne baziraga kooti, oyo omujulizi ow'e13 yazireeta ne bakakasa engeri emmotoka ekika kya RAV4 yatambulamu nga lumu Ogwokuna 2026 era ne balaga ne boda bwe yatambula ng'emuleese nga 2 Ogwokuna 2026.
Whereas the defense counsel during his submissions claimed that the images were not clear, it is not true because the accused person could be clearly identified when he alighted the vehicle at Renewal Circle on 1st April 2026 and also while on a border on 2nd of April 2026.
Nti oludda olwawaabirwa abalooya bagamba nti ebifaananyi byali tebirabika bulungi naye baali si batuufu kubanga baamulaba bulungi ne bamwetegereza bwe yapaakinga ku Renewal Sacco nga lumu Ogwokuna 2026 era ne baddamu ne bamulaba ng'ali ku booda nga 2 Ogwokuna 2026.
The prosecution had earlier on adduced the evidence of PW8 is called Hashim Juma, one of the directors of Trip Car Rental Uganda, who testified that the motor vehicle belongs to his company and the accused had hired it from him to be used on the 1st and 2nd of April 2026 on self-drive.
Nti baleeta omujulizi ow'omunaana nga bamuyita Hashim Juma, ono yali yapangisa omuwawaabirwa emmotoka ekika kya RAV4 yali yakozesebwa nga lumu n'olunaku z'omwezi 2 Ogwokuna 2026 nga yali agenda gyevugira.
However, the accused person used the motor vehicle only on 1st April 2026 because it got mechanical defects. This testimony was corroborated by the CCTV evidence where the accused person was seen in the footage of 1st April 2026 pushing the vehicle at Shell Kitgum House, Ginger Road at 2 p.m. with the assistance of the staff of Shell.
Nti emmotoka yagikozesa nga lumu Ogwokuna 2026 wewuka kubanga yamala nefuna ebizibu era kino kyongerezebwako obujulizi ono yaleeta obujulizi bwa kamera ng'agamba baamulaba ng'asindika eno emmotoka ku Shell Kitgum House Ginger Road zaali ssaawa 8 ez'emisana nga bakola ku Shell be bamuyambako okugisindika.
The accused had earlier on called Hashim and told him about the faulty car, and Hashim had advised him to park it at Shell Kitgum House.
Nti yali yakubidde Hashim n'amugamba nti emmotoka yali efunye obuzibu era n'amugamba nti agipaakinge ku Shell ya ku Kitgum House.
In the footage of 2nd April 2026, the accused could be easily identified putting on a checkered black, white, and grey shirt and black sunglasses when he was on a border.
Nti ku katambi ke baleeta ng'akaali ka 2/2026 omuwawaabirwa baamulaba bulungi ne bamutegeera kubanga yali ayambadde yali ayambadde essaati y'ebikuubo ate nga yali ayambadde ne galubindi.
And this is corroborated by the evidence of the SOCO, that is the Scenes of Crimes Officer, and the investigator who recovered the said sunglasses stained with blood at the primary scene and took the said shirt from the accused person upon his arrest and submitted both items for the DNA analysis.
Kino kyongereza ku bujulizi bw'oyo omupoliisi agenda mu bifo by'obazizaamu emisango kubanga bwe yatuuka mu kifo ekyo n'asanga galubindi ezaaliko omusaayi n'aziggyayo era n'amuggyako n'essaati eyo n'abisindika mu beekebeja ebintu ebyo.
The DNA analysis revealed that the cuttings from the shirt contained the DNA of the accused person, while the sunglasses, which were stained with blood, had mixed DNA of both the accused person and of Keisha again Roth, whose body had been labeled as body 39 by the Scenes of Crimes Officer.
Nti mu ndagabutonde bwe baakebera essaati gye bajja ku muvunaanibwa baagikebera nga yaliko ondagabutondo ye era ne bakebera ne galubindi ne basanga nti waliwo endagabutonde ya omuwawaabirwa neya Keisha ate nga Keisha omulambo gwe baali bagutaddeko namba 39.
Prosecution also adduced evidence that the accused person was cutting the children with a knife, which he threw over the chain link fence upon seeing the first responders at the scene. The knife was recovered by the Scenes of Crimes Officer. It was a kitchen knife with a silver handle and black blade with the label reading Ming Feng. And while at the laboratory, a swab from the knife handle was taken, and also a swab from the blade was taken. And it was established that the handle had a male DNA profile which belonged to the accused person.
Nti obujulizi bwonna bugamba nti yali abaana bano nga basaza akambe era abantu bwe batandika okujja akambe n'akasuula wabweru wa geeti akambe kano kaliko ebigambo Ming Feng nti bwe baamala akambe ako ne bakatwala kukeekebeja bwe baamala okukeekebeja ne basanga nga waliwo endagabutonde z'omuwawaabirwa.
Also, the blood stains on the blade of the knife were for body 3 and body 37. And body 3 was for Okello, while body 37 was for Seriange Ignatius.
Nti era ne akambe bakajjako omusaayi ogwaliko ne bagenda kukeekebeja ne basangako endagamutonde za Ryan ne Seriange.
Whereas the accused in his defense did not deny the killing of the children, the defense, this defense will be discussed at length while discussing the last ingredient.
Nti wadde mwawulira teyeegaana ekyokutta abaana abo naye ensonga egye yawaayo ekitiibwa Omulamuzi agenda kugyogerako.
During the submission of counsel for the accused person, attempted to suggest that the accused person was not adequately implicated for the offense, and his argument was based on the fact that whereas PW6 and PW7 testified that they were first responders. There were first responders, namely Cyrus and Moses, who are said to have apprehended the accused person, and kept him in the guardhouse. None of those first responders was called as a witness. And he wondered where exactly the police found the accused person to arrest him.
Nti abaloya nga babumbawumba obujulizi lawyer w'omuwawaabirwa yagamba nti oludda olwabi lwalemererwa okuleeta obujulizi obumala okukakasa nti omuwawaabirwa ye yaza omusango guno nti ng'agamba nti waliwo abantu abasooka okujja nga Cyrus ne Moses naye tebabaleeta mu kooti naye neyeebuuza poliisi yamusangawa okumukwata.
I note that whereas it was prudent to have one of those witnesses to come to court, failure to have them did not affect the prosecution evidence. At least PW6 and PW7, that is Phoebe and Annette, testified that they saw the accused person being apprehended and being kept in the guardhouse, and PW15 and PW14, that is the investigator, the lead investigator, and the SOCO, the scenes of crimes officer, they confirmed finding the accused person having been arrested and kept in the guardhouse. That evidence was not challenged at all in cross-examination, and in light of all the other evidence placing the accused person at the primary scene of crime, it is my finding that the accused, that the evidence that the accused was apprehended in the act of slaughtering the children, kept in the guardhouse and later picked up by police is true.
Ntera bagamba omusibwa Omulamuzi agamba kituufu abano abantu abasooka okujja bandize mu kooti ne bawa obujulizi naye ne bwebaba nga tebaze kubanga Phoebe ne Annette bajja ne bawa obujulizi ne bagamba nti baaliwo era ne balaba nti bamukwata ne bamutereka mu kayumba k'omukuumi era waliwo obujulizi obulala bw'omujulizi w'okuminabana n'owokuminabataano era bajja ne bagamba nti basanga ng'omuwawabirwa bamaze okumukwata ne bamutereka mu kayumba k'omukuumi. N'olwekyo okusinziira ku bujulizi Oweekitiibwa Omulamuzi agamba kituufu omuwawabirwa bamukwatirawo ng'akola omusango ogwo era ne bamukwata ne bamutereka mu kayumba k'omukuumi.
In light of the above, it is the finding of this court and in agreement with the joint opinion of the assessors that the prosecution has proved beyond reasonable doubt that the accused person caused the death of the 4 children, namely Eteku Gideon, Keisha Agenrotho Tim, Seriang Ignatius, and Odeke Ryan.
N'olwekyo Oweekitiibwa Omulamuzi akkanyiza ne ba assessor bwe bamuwabula abagamba nti oludda oluwaabi luleese obujulizi obumala okulaga nti mu butuufu abaana bano Eteku, Keisha, Seriang ne Odeke baafa.
I will go to the last ingredient, and that is the ingredient of malice aforethought.
Kati agenda kwogera ku ky'okugamba nti eyata abaana bano yali alina ekigendererwa.
Malice aforethought is defined in section 174 of the Penal Code Act. And the summary of it is that malice aforethought shall be deemed to be established by evidence provided for by the following circumstances. An intention to cause the death of any person, whether that person is the person actually killed or not. B, knowledge that the act or omission causing death will probably cause the death of some person, whether that person is the person actually killed or not, although the knowledge is accompanied by indifference, whether death is caused or not, or by a wish that it may not be caused. In summary, that you must have had an intention to kill somebody, or you had knowledge that your acts or your failure to act would actually result into the death of a person.
Ekigendererwa ekitabo ky'ebibonerezo akawayiro 174 kigamba nti obujulizi bulina okulaga nti waliwo nnyo ekigendererwa okutta omuntu n'obwoba nga ogose siku wali oyagala kutta olina okubeera ng'omanyi nti bino byonna by'oli mu kukola biyinza okuviirako kufa kw'omuntu. Ekikulu kiri nti olina okuba ng'omanyi nti byonna by'ogenda okukola biyinza okuviirako omuntu okufa.
So malice aforethought is a mental element, and it is not easy to prove with direct evidence. But inferences may be made from a number of things, including the nature of the weapon used, the part of the body targeted, the nature of injuries, and the conduct of the accused person before, during, and after the commission of the offense.
Ekigendererwa kibeera mu mutwe gw'omuntu n'olwekyo kiba kizibu nnyo okuleeta obujulizi okukiraga naye basobola kukirabira ku bintu bingi. Ekisooka basobola kulabira ku kisi ekikozesebwa, basobola kulabira ku kitundu eky'omubiri kye bakozesa, era basobola kulabira ku biwundu oba obuvune omuntu bw'afunye ate basobola kulabira ku neeyisa y'omuwawaabirwa mu kukola ekintu ekyo ng'akikoze oba nga tannakikola.
Prior planning or prior threats of the accused may be used to infer malice or forethought.
Omuntu okusooka kuteekateeka ekintu basobola okukiraba ne bagamba nti yali alina ekigendererwa.
To prove these ingredients, the prosecution adduced evidence from eyewitnesses to the offense, that is Phoebe and Annette, who testified that they saw the accused person aggressively and gruesomely cut the necks of the 4 children with a knife.
Nti oludda olwabi lwaleeta obujulizi bw'abantu abaaliwo nga Annette ne Phoebe era bajja ne bagamba nti baalaba omuwawaabirwa ng'asala bubi nnyo ensingo z'abaana bano.
This evidence was corroborated by the findings of the post-mortem examinations of the 4 children's bodies and by the testimony of Dr. Katongole Abdul, who examined all of them and described the injuries on the deceased as follows.
Era ekyo kyongereza ku bujulizi za postmortem reports oba ebbaluwa reports omusawo gwe bayita Katongole ze yawandiika ng'amaze kwekebejja emirambo gy'abaana bano n'annyonnyola ebiwundu abaana bye baafuna nga bwe tugenda okubyogera.
And I will go in the detail of the injuries for each of the deceased children. I begin with Eteku Gideon. He is said to have had a 14-centimeter long open wound on the right side of the neck, located at 66 centimeters from the right hem of the neck. The wound was longer than its depth, characterized by smooth edge, regular margins, no bridging fibers, marginal contusion, and the wound was deep, transecting through the esophagus, trachea, internal jugular vein, cut fractures, and the above descriptions were consistent with deep cut wounds.
Tusooka ne Eteku Gideon yalina ekiwundu obugazi nga kyali kya sentimita 14 ate nga kyali ku bulago sayidi eya ddyo nga kyali kiwanvu nnyo nga kifumitira ddala ne kyonoona ebitundu ebisinga eby'obulago era nga kiraga nti baamusala nnyo.
Keisha Ageno Roth Otim was said to have a 9-centimeter long open wound on the right side of the neck at 67 centimeters from the right hem and 1 centimeter from the anterior midline, and the wound was longer than it was deep.
Nti Keisha naye yali alina ekiwundu nga kyali kya bugazi sentimita 9 ate nakyo kyali ku bulago sayidi ya ddyo nti kyali kiwanvu nnyo.
The wound was big, transecting through the skin, underlying neck muscles, the trachea, esophagus, major neck vessels, and nerves.
Ekiwundu kyali kiwanvu nnyo nga kiyita mu mubiri ne kisala emisuwa egisinga egy'obulago.
And he concluded, or he noted, that these findings were consistent with deep cut wounds.
Era n'agamba nti ebiwundu ebyo byaliwo olw'ensonga nti baamufunita nnyo.
Seryange Ignatius was said to have had a 14-centimeter long open wound on the right side of the neck, which was longer than it was deep.
Seryange naye yali alina ekiwundu nga kyali kya sentimita 14 ate nga bali bamusaze nnyo.
The wound was deep, transecting through the skin and underlying neck muscles, injuring the internal jugular vein.
Ekiwundu kyali kiwanvu nga kisala ne kiyingira ne kisalira ddala emisuwa gy'obulago.
He found that the above descriptions were consistent with deep cut injuries.
Era n'agamba nti ekiwundu kino kyajja olw'ensonga nti baamusala nnyo n'afuna obuvune.
This one also had another 4 centimeter long cut wound located on the right submandibular region. We go to Okello, the last child. This one was said to have had a 9 centimeter long deep cut wound located on the right side of the neck. It was a deep cut wound dissecting through the underlying neck muscles, neck vessels, trachea, esophagus, and transection of a spinal cord. The cause of death for all the children was established to be hypovolemic shock due to cut wounds to the neck.
Odeke naye yali alina ekiwundu nga kyali kya sentimita 9 nga kirina ku kono y'obulago era ng'ekiwundu kino kyali kiwanvu nnyo nga kisalira ddala emisuwa egisinga egy'obulago nga kigendera ddala ku nkizi. N'agamba nti kyaviirako omwana ono okufa, baamusala nnyo n'avaamu omusaayi mungi.
All the postmortem reports for the 4 children were admitted and marked as exhibits 1, 2, 3, and 4 respectively.
Alipoota z'omusawo ze yakeberako abaana bano banna zonna baazireeta mu kooti ng'ebizibiti ekisooka, ekyokubiri, ekyokusatu n'ekyokuna.
This evidence is further corroborated by the evidence of the scene of crimes officer, Mr. Mutaka Jimmy, who visited the primary scene of crime. This is the center. Immediately after the commission of the crime, he processed it and made a report, which was admitted as PEX-10. And this is what he said, that at the center, he found the body of an infant on the veranda, and it was identified to him as that of Okello. And he uniquely marked that body as 3. On this body, he observed 1 deep cut injury on the right side of the neck, with cuttings through the neck bones and muscles. And he took pictures of this body, and they are in his report on page 11 and 12.
Nti kino kyongerezebwako obujulizi bwa soko oba omupoliisi agenda mu bifo bye bazizaamu omusango bamuyita Mutaka Jimmy, era yagamba nti yagirawo mu kifo ekyo n'awandiika alipoota gye baleetanga ekizibito ekyo-10. N'agamba bwe yatuuka mu kifo ekyo yasanga omwana omuto, omulambo gw'omwana omuto eyali ku kabalaza nga bali bamuyita Ryan, n'aguteekako namba 3. Agamba nti omulambo guno gwali gulina ekiwundu ekinene ku bulago, ng'ekiwundu kino kyali kisala amagumba n'emisuwa egy'obulago, era n'akuba ebifaananyi n'abiteeka mu alipoota eyo.
Shortly thereafter, he went to Wenzi Medical Center, this is the secondary scene, where he found the bodies of the 3 children, and they were identified to him as Eteku Gideon. He uniquely labeled his body number 32, Seriang Ignatius number 37, and Keisha Ageno Rotho team was labeled 39.
Omupoliisi oyo yayongera n'agenda ku Wenzi Medical Center, bwe yatuukayo ne bamulaga emirambo gy'abaana 3, Eteku n'amuteekako namba 32, Seryange n'amuteekako namba 37, Keisha n'amuteekako namba 39.
PW14, this is the scenes of crimes officer, further testified that all presented similar fresh injuries of deep cuts on the right side of the neck, which went through the muscles and bones.
n'agamba nti abaana bano baali balina ebiwundu nga byagala kufaanagana nga bonna baali balina ebiwundu mu bulago ku ddyo ate ng'ebiwundu bino byali bisalira ddala nga bisala n'amagumba n'emisiwa y'obulago.
This court also observed the photographs of the bodies of the 4 infants and confirmed the gruesomeness of the attack on all of them as evidenced by the nature of the injuries.
Era kooti yatunulira ebifaananyi by'abaana abo n'ekakasa engeri abaana gye baafaamu baafa bubi.
The murder weapon, which is a knife, which caused those grave and fatal injuries on the children, was also recovered at the primary scene of crime just behind a chain link fence after being thrown by the accused person, and it was also admitted as evidence.
Ntera n'ekisi akambe baakafuna nga baali baakasuula wabweru ya geeti ne bakaleeta mu kooti ng'ekizibiti.
So we have those grave injuries and the knife that caused them.
Tulina ebiwundu ebyali ebibe ennyo n'akambe akaakozesebwa.
The above evidence would be sufficient to prove malice aforethought because there would be no other inference that a person pounces on defenseless, innocent babies and goes ahead to cut their necks as if slaughtering a goat or a chicken in that accurate and precise manner other than that of malice aforethought.
Nti era ku bujulizi obwo bulina okuba nga bumala kubanga omuntu tasobola kugenda n'akwata obwana obuto nga tebusobola n'abusala obulago ng'asala embuzi oba enkoko.
However, the defense heavily contested this ingredient and insisted that the accused person was not in a right state of mind to form an intention to commit the offense of murder.
Nti oludda olw'omwawabirwa baloya be bagamba nti ebyo si bituufu kubanga nti omwawabirwa omutwe gwe gwali tegukola bulungi n'olwekyo yali tasobola kutemula.
The accused person in his unsworn statement stated that he did not act intentionally or deliberately, and although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected, which could have contributed to the death of the children. He insisted he was not mentally okay.
Nti bwe yali ayewozaako teyalayira naye n'agamba nti ye kino teyakikola mu bugenderere n'agamba wadde nti bagamba nti omutwe gwe gwali gukola bulungi naye bayinza okubawo ebintu ebirala bye bataategeera ebiyinza okuba nga byamuviirako okukola ebyo bye yakola n'akakasizza ensonga egamba nti ye omutwe gwe tegukola bulungi. Omutwe gwe gwali tegukola bulungi.
The accused also denied being four-minded in the killing of the children, and in respect to this, he made reference to the book. I already talked about that, but this is for emphasis, that the flash disk which showed that he had done a search and saved a book on the art of war. He stated that he did it long ago and it had nothing to do with the death of the children.
Nti era agamba nti ekino ekintu kyonna teyakiteekateeka ekyokutta abaana n'agamba nti ekyokuteeka akatabo k'entalo n'okunoonyereza byonna bye yanoonyereza agamba nti akatabo yakanoonyerezako ebiseera by'emabega nnyo tebiyinza okuba nga bye byamuviirako okutta abaana abo.
He also denied being deliberate and with forethought while making reference to the evidence of the Google searches that he made using his phone, specifically the search for ISIS beheading and for schools that teach young children. And he said that whereas these searches may suggest that he did it deliberately, there were other factors forcing him to make those searches, which factors he chose not to disclose to the court.
Nti era yagamba nti ye teyabikola mu bugenderere era n'agamba nti bino bye yanoonyerezaako ku mukutu ng'ebya ISIS okuggyako emitwe amasomero agasomesa abaana abato nti naye waliwo ebintu ebirala ebyamuleetera okunoonyereza ku bintu ebyo.
you have not also interpreted the factors. Those factors, he did not disclose them to the court.
Nti ebintu ebirala ebyamuleetera okunoonyereza ku bintu ebyo teyabibuulira kooti.
The accused person further stated that he was under the control of some people whom he occasionally referred to as friends and were in 3 categories.
Nti yagamba nti yali akola olw'ensonga y'abantu be yali ayita mikwano gye ate nga baali bangeri 3.
He also alluded to the fact that between January 2026 and March 2026, he entered into a distressing period because he was contending with some people who were surveilling him, making demands from him, and they threatened to kill him.
Nti yagamba nti wakati w'omwezi gwa January n'ogwokusatu 2026 yali mwenyamu nnyo olw'abantu be yali abali bamusumbuwa era nga agamba abaali bamutambulirako era kyekyamuviirako okukola ebintu bino.
They began, according to him, they began demanding for money, and he noticed that they had all the capabilities and they were following him closely. And as a result, he left his the neighborhood of Bunga, where he was staying, and resorted to sleeping on the streets.
Nti baali bamusaba ssente era nga yalaba nga baali balina obusobozi nga bamugoberera nnyo kyekyamuleetera kuva Bunga gye yali abeera n'agenda n'atandika kubeera ku luguudo.
The accused person stated that as a result of this, he tried to end it somewhere and somehow, so as to bring the whole thing to an end. And according to him, he tried to flee the country, tried to rob a bank, and tried to kill his brother's family. He then said that those people whom he at times referred to as his friends during his testimony had something to do with his actions of 2nd April 2026.
Nti yatuuka ekiseera n'ayagala okukikomenkereza n'asalawo ave mu ggwanga n'agezaako okubba banka n'agezaako okutta famire ya muganda we n'agamba nti abantu abo be baali balina kye balina ku kyatuukawo nga 2 Ogwokuna 2026.
He invited the court not to honor the charges of murder because there were some circumstances that forced him to act the way he did on 2nd of April.
N'asaba kooti ereme okumusingisa omusango ogw'obutemu ng'agamba waliwo ensonga ezamuleetera okukola bye yakola nga 2 Ogwokuna 2026.
Unfortunately, he neither stated the circumstances he claimed forced him to act that way, nor did he disclose the identities of his friends who may have compelled his actions on 2nd April 2026.
Ntebyembi teyayogera biki ebyamuleetera okukola ebintu ebyo bye yakola nga 2 Ogwokuna 2026.
No, he did not state the circumstances, and he also did not disclose the identities of those friends of his.
Nti ebintu ebyo ebyamuleetera okukola bye yakola ate n'amanya oba okwogera abaani abamuleetera okukola ebyo bye yakola 2 Ogwokuna 2026 teyabyogera eri kooti.
And because he made an unsworn statement in his defense, he could not be probed to give more information.
Olw'ensonga nti teyalayira ng'awa obujulizi baali tebasobola kumubuuza ebibuuzo bingi ku kino.
By the above claim, the accused raised a defense of insanity.
Olw'ekyo yagamba nti ye omutwe gwe gwali tegukola bulungi mu kaseera ako.
The defense of insanity is provided for under Section 11 of the Penal Code Act, Chapter 128.
Nti ekyokugamba nti omuntu omutwe guba tegukola bulungi ekitabo kya bibonerezo kikyogerako mu kawayiro ka 11.
And this is what it provides: that a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission, he or she is through any disease affecting his or her mind incapable of understanding what he or she is doing, or knowing that he or she ought not to do the act or omission, Although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other of the effects mentioned in this section in reference to that act or omission. I will summarize this to mean that the accused, somebody must show that he had a disease of the mind, and as a result of the disease of the mind, he was incapable of knowing the nature and quality of his actions at the time when that action is said to have been done. That's a summary of this law.
Nti etteeka lino mu bufunze ligamba nti omuntu alina okukakasa nti yali alina obulwadde bw'obwongo, nti ate okubeera n'obulwadde obwo nti yali tasobola kumanya ebikolwa bye yali akola kye bitegeeza oba ekiyinza okumuviirira mu bikolwa by'akoze.
So if it is found that actually he had a disease of mind, and that disease of mind made him incapable of understanding what he was doing and what its consequences would be, that would be a total defense to him.
Nti bw'agamba nti yali alina obulwadde bw'obwongo nga tasobola kutegeera biki bye yali akola, awo aba yeewozezaako.
And for the offense of insanity to stand, the accused person must satisfy the ground set out under the Magnaten rule. And the test is purely cognitive, and the defense must show whether the accused understood his or her actions or that his or her actions were wrong. The defense of insanity is twofold. First, that an insane defendant does not have control over his or her conduct, similar to somebody who is sleepwalking, not knowing what they're doing. And secondly, that the defendant does not have the ability to form a criminal intent. Without the ability to control conduct or the understanding that conduct is evil or wrong by society standards, an insane person or defendant presumably will commit crimes again and again. This person must not be in control of anything to do with himself. He cannot control his actions because of the disease of the mind. These rules require that the three tests should be proved. One, that an individual suffers from a defect of reason, which is caused by a disease of the mind, and that as a result, he or she does not know the nature and quality of his act, or that that act is wrong. And when somebody raises a defense of insanity, when he says I was not normal, like the accused person said that he was not mentally okay, then it becomes his responsibility to prove to the court that actually that was the condition that he was in at the time the offense was committed.
Nti omuntu okugamba nti omutwe gwe gwali tegukola bulungi alina okukakasa kooti nti yali tasobola kutegeera ebintu byali akola oba byali bituufu oba byali bikyamu oba byali si bikyamu, nti alina okulaga nti yali tamanyi biki byali bigenda mu maaso n'ebintu bye yali akola, abeera ng'omuntu atambula ekiro nga yeebase nga tategeera biki ebigenda mu maaso. N'agamba nti omuntu bw'atyo aba tasobola kubeera mu mutwe nga ateekateeka ekintu okukola ekintu ekikyamu kubanga aba tasobola kumanya ekikyamu oba ekituufu. N'agamba nti aba tasobola kwesalirawo biki by'akola olw'ensonga nti alina obulwadde bw'obwongo.
The defense of insanity seeks to do away with an essential requirement of malice aforethought, and it seeks to prove that the accused person did not have the intention to cause death, neither did he have knowledge that such an act or omission would cause the death. And this is because of the presumption of sanity, which is provided for in Section 10 of the Penal Code Act.
Nti okugamba nti omuntu omutwe gwe gwali gulina obulwadde baba baagala okugyako ekyokugamba nti omuntu yalina ekigendererwa okutta abantu naye
there is a presumption of sanity.
Naye waliwo amateeka agagogera ku ky'omuntu okubeera nga omutwe gukola bulungi.
And it provides, in Section 10, provides that every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question until the contrary is proved.
Era etteeka Kawayiro ka 10 kagamba nti buli muntu yenna bamutwala nti omutwe gwe gukola bulungi oba talina bulwadde bw'obwongo okutuusa nga baleese obujulizi okulaga nti mu butuufu omuntu oyo akaseera ako omutwe gwe gwali tegukola bulungi.
This presumption of sanity puts the burden on anyone who claims insanity as a defense to prove that he or she was not in the right mental state at the time of the act or omission.
Kino kiraga nti omuntu agamba nti omutwe gwe gwali mulwadde oba ng'alina obulwadde bw'obwongo alina okuleeta obujulizi okukakasa nti akaseera ako omutwe gwe gwali tegukola bulungi oba yali alina obulwadde bw'obwongo.
And I have already said that when anyone advances a defense of insanity, he bears the burden to prove it, though not on as a higher standard as the prosecution has to prove the case against him beyond reasonable doubt.
Era nga bwe yagambye nti omuntu bw'agamba nti yali alina obulwadde bw'obwongo yalina okuleeta obujulizi okukakasa nti mu butuufu yali alina obulwadde bw'obwongo mu kaseera ako.
I have cited a number of cases which can be found in the judgment. Having laid down the above principles from the law and the decided cases, I will proceed to evaluate the evidence adduced by the accused person in a bid to prove the claim or the defense of insanity.
Amaze okutunuulira obujulizi bwonna agenda kutunuulira.
No, I have said having laid down the above principles from the law and the decided cases on the defense of insanity.
Oweekitiibwa Omulamuzi ng'amaze okwogera ku mateeka agakwata ku ky'obugamba nti omuntu omutwe gwe amateeka n'emisango emirala egyayogerwako ku bulwadde bw'obwongo kati agenda kutunuulira obujulizi bwe baleeta obukwata ku bulwadde bw'obwongo.
I will need to establish whether the accused person was suffering from the disease of the mind at the time the offense was committed, whether that disease of the mind rendered him incapable of knowing the nature and quality of his actions, and whether